great to have you all with us today, whether you're a regular joining us or whether it's your first time. You're all very welcome. I'm Kelly Dace and I'm presenting on behalf of Access Skills. As always, these webinars are designed to support managers in the health and social care sector by tackling real workplace challenges and giving clear, practical guidance that can help you in your services. For this month's webinar, we're focusing on a really important topic, and that's understanding employment tribunals. And we'll be exploring what tribunals are, why they happen, and really importantly, what managers can do to reduce the risk and feel more confident if something like this arises in their workplace. We'll be working through a series of questions, so as always, feel free to add your own additional questions, and if we've got time, we will go through them, but they may be used in future webinars if we don't have the time. You can write the questions by looking on the GoToWebinar panel, and there should be a grey bar or a button which says questions, or it looks like a question mark depending on the device that you're using. Click on that and type your question underneath. So once again, I am delighted to be joined by Kane, and he's our recruitment and HR specialist with extensive experience in supporting care providers through complex employment matters. So Kane, welcome back. Great to have you here again.
Good to be back. I think this one will be a real good topic for people to get a little bit more insight on. I speak with a lot of managers that feel, I suppose, lacking in confidence when it comes to decision making. What can we do, what can't we do? So I think it gives it's a great opportunity to have a look at the other side of the coin. How this works from a legal point of view. So really looking forward to this one.
Fabulous. So before we do get started with the questions, Kane, can you just give everybody a quick reminder of your background and experience, particularly for those joining us for the first time?
Yeah, sure. So my name is Ken Keeling-Treasure. I'm a senior business consultant over at Croda. I specialise mainly in employment law, but more recently I've been taking on the likes of health and safety executive prosecutions, personal injury claims and such like. So I work quite heavily within the health and social care sector. So the majority of my direct clients are domiciliary care, residential care, semi-independent, children's homes. So anyone regulated by the CQC or Ofsted respectively, mainly. So yeah, have a wealth of knowledge with dealing with highly complex staff related issues, but also the flip side of the matter being employment tribunal claims as well.
Fantastic, thank you for that. So let's get stuck into our first question. So the first one, can you tell us what is an employment tribunal and what types of cases can be brought against care employers?
Sure. So an employment tribunal is whereby an employee will either leave or continue their employment, but raises a claim against that employer. Now, the claims can come in a lot of different shapes, sizes and forms. It can be the more common ones, such as, let's say, unfair dismissal, constructive unfair dismissal, automatic unfair dismissal. It can be a variety of discriminations, whether that be on the grounds of sexual orientation, whether it be disability discrimination. There's also sexual harassment, which is now protected by whistleblowing laws. So that's classified as public interest disclosure, which is the fancy way of saying whistleblowing. The failure to supply terms and conditions, I mean, the list goes on. I think there's probably around about 50 or 60 different jurisdiction codes, so different types of claims that can be brought against an employer, ranging from, again, some of the more minor ones being failure to supply terms and conditions, to a couple more serious ones being discrimination, whistleblowing, failures with health and safety, but also the likes of breach of contract and unlawful deductions from wages. So yeah, these claims get put in front of a judge, and a decision is made ultimately.
Fabulous, great overview, great place to start there. So next question asks, what are the most common reasons care providers end up at a tribunal?
I think there's a lot of different reasons that a care provider can end up at an employment tribunal. More often than not, I think certainly in my line of work, I think the vast majority of claims that I tend to deal with, I'll probably go as far as to say maybe 70 or 80% are cases whereby an employee is proverbially throwing things at the wall to see what sticks a lot of the time. More often than not, an employee is terminated because of their performance potentially, and they go on to claim at a tribunal, with the narrative being something that resembles, in actual fact, I don't feel that I was terminated because of my performance. I was the only person of my ethnic background, or there was odd sponsorship within this department, and that's why I feel that I was terminated. I think that it was automatically unfair, and I feel that I've been discriminated against in the process, or it's because of my disability potentially, and so on and so forth. So I think, unfortunately, there's not a lot an employer can do to stop an employee raising a claim. Unfortunately, that's something that we can't do. But what we certainly can do is prepare to make sure that we can put forward the best defence possible. And it all starts well before the employment tribunal is raised. It's very uncommon for an employment tribunal to happen overnight. More often than not, especially in the successful claims, it's, I suppose, a chain or a pattern of failures along the way, and it all starts with your documents. So I think the easiest way to surmise it, and you may hear me repeat this throughout the webinar, many employers, in my experience, are what we call morally correct but procedurally wrong. And I suppose it makes sense. I think a lot of my direct clients, have been working in health and social care for 10, 15, 20 odd years, got a wealth of experience, and then they decide to open up their own provision. They build this business from the ground up, and certainly if someone is then going to claim against that business and potentially harm its reputation, its reputation with the public, its suppliers, etc., that is something that certainly I would take very personally. But unfortunately, employment tribunals aren't a place for emotion. It's just the law. It can be quite unforgiving at times. So again, hopefully we're able to, I suppose, demystify and understand a little bit more around ways to avoid it. But the most common claims for me are disability discrimination and unfair dismissal. They're the main claims.
Thank you for that. Another insightful answer as well. So the next question asks, how soon must an employee start a tribunal claim after leaving employment?
So an employment tribunal can be raised, and many people tend to overlook this, pre, during and post employment. So employment rights actually start at the job advertisement stage. There was a serial claimer called Mr. Ramos, I think it's Mr. G. Ramos from memory, who used to apply for different cleaning roles and things like that at the job advertisement stage and would be successful in the claim. A lot of them were on the grounds of sex discrimination. A lot of the ads that he would apply for were wanting, say, a female cleaner as an example, and again, he had no prospect of ever being employed by the company, but he was a serial claimer. And there was one more recently that was in the news of an employee that is now banned from raising employment tribunals because they were doing something similar. In terms of answering the question, in terms of how soon must an employee raise a claim post-employment, so the current statutory limit is 3 months less 1 day from the last day worked in the organisation. This is set to change with the emergence of the Employment Rights Bill, so the window will be shifted to 6 months post-employment that an employee can raise a claim, but that's not always the case. There's always going to be exceptions to the rule. In some instances, an employee can fall seriously ill, maybe they've been off on long-term sick, the employer goes through a process, they terminate their employment, but naturally, due to ill health, the employee couldn't raise the claim within that window. So the tribunal does have jurisdiction to accept claims that will be considered out of time, but again, there needs to be just cause for it. But in 90% of the cases, you'll be looking at that 3 months less 1 day window post-employment.
Great, useful to know. Thank you for that. So can I just ask a question then? So these serial claimers, they were doing that just to make money, were they? Is that what they were doing? Yeah. They would
scour Indeed, Total Jobs, whatever it might be, and again, they would effectively claim against that employer, never having worked a day for them because the job advertisement was discriminatory. So again, many people overlook and just think, well, they've never worked a day for me, it's got nothing to do with me. But the employee rights start at the job advertisement stage. An employee can claim against you, never having worked a day for you.
Wow. Okay, something new for me there, Kate. Yeah, thank you. Yeah, I'll be on Indeed this afternoon. So next question, what is ACAS early conciliation and why is it so important before a tribunal claim can proceed?
Well, I think just understanding, I suppose, the stress that is currently on employment tribunal venues across the UK at the moment. I think the lowest reported figure that I was able to find was that there's around about 50,000 claims that are backlogged in employment tribunals at the moment, but I've also seen some higher reported figures touching on 400,000 claims that are backlogged. So again, I think this is extremely important for employers because, again, you must understand that if there's such a backlog and such a strain on these employment tribunals, you might be waiting the better part of 2 years before you even get to an employment tribunal hearing. And again, when you think of all the legal fees that you might rack up within that period of time, I think when we did the exercise at head office, I think we calculated that the average employer will spend £13,000 before they've even set foot in an employment tribunal. And that was maybe 2 or 3 years ago, so you know it sort of pales in comparison to what I imagine those numbers are now. But ACAS are the advisory conciliation arbitration service, so their role is to ideally settle the claim without it getting to an employment tribunal. So a lot of the time it's there to ease the burden on the employment tribunal, but also provide a quick resolution. You know, if an employee is claimed against a business, you know, for 6 weeks notice pay, again, the employer has the opportunity to engage in that conciliation process to settle the matter without it getting to a hearing. So it does, you know, neither parties are obliged to engage in that conciliation process. Some employers and some of my clients have just said, I'm not interested in it, you know, I'm not interested in settling for this amount, I want my day in court, and vice versa with the employees as well. But it is, you know, I suppose a useful tool to understand, I suppose, the value of the claim, to understand what the claimant is looking at in terms of resolution, and to figure out, you know, is this going to be a viable option for me, or is this something that, you know, I want to see play out in court.
Great, really key step for employers to understand there for that as well. So next question is an interesting question. Before I ask this question, I can see a few hands raised. We can't take verbal questions, but what you can do is click on the questions box on the GoToWebinar panel. That's a grey box, probably says questions or has the question mark shape, and click on that and type a question underneath. It's just me and Kane who can view those questions, and if we've got time, I'll read them out. So thank you for that. So moving on to the next question that I do have here. Can an employee take an employer to tribunal while they're still employed?
Yeah, absolutely. You know, there are some claims that wouldn't make sense to be raised if still employed. An example being unfair dismissal. If you've not been dismissed, then you can't raise that claim naturally. But more commonly, you know, the claims that I see whilst an individual is still employed are discrimination or unlawful deductions from wages, more often than not. Those tend to be the claims. So for unlawful deductions from wages, this can be incorrect holiday pay that's been paid to this individual, you know, paying on their base salary, not taking into account bonuses and things of that nature as well. So that can justify unlawful deductions from wages. It can also be deductions that have been made for, I don't know, let's say that an employee has allegedly broke some equipment or whatever it might be. No investigation's taken place, but the money for that piece of equipment has been deducted from that individual's salary. Also, if training costs have been deducted without prior agreement, that this could be deducted from their salary. Again, in a situation like that, we're looking almost exclusively at the contents of the contract and any supporting means of documentation, such as training costs agreement that's here outside of that document as well. And again, they're called short track claims. It's sort of a matter of fact. You either have deducted unlawfully or you haven't. So it's more of a matter of fact, calculations are put forward. Again, you wouldn't really expect something like that to be going on over a period of days at an employment tribunal. But that's not to say that they can't be as damaging as some of the larger claims, such as discrimination and things of that nature. Because consider the following. I mean, if one claim for incorrect holiday pay is successful, well, that ruling will end up in the public domain. Well, if you're an employer that's got 50 members of staff, how likely is it that the other 49 members of staff will also say, well, hang on, Joe Bloggs has just earned £3,000-4,000 that he was owed. I'm going to do the same. So again, these are some common claims that we deal with. Also, employment status. This is something that is largely overlooked. If you're working with someone that is an independent contractor, or potentially they're considered a worker and not an employee, if you don't have the correct means of documentation, or if the working relationship turns out in a certain type of way, a worker can claim that in actual fact their relationship is that they're an employee, not a worker or an independent contractor. And if I've been working for the company, on an ad hoc basis, I'm an independent contractor, or maybe I'm a worker for 2, 3, 4 years, this can expose the employer to 4 or 5 years, backdated holiday pay, sick pay, minimum wage, top-ups and things of that nature as well. So again, you'll be looking at documentation for a situation like that. But also discrimination is something that can be raised during employment. Let's say someone was passed up for a promotion. You have a role, 2 people apply internally for it. One of the employees gets the job, the other employee doesn't get the job, but then raises a grievance citing age discrimination. Potentially this individual is slightly older, maybe 60 or something like that. They say that they were overlooked for said promotion based specifically on their age. They weren't happy with the outcome of the grievance, but also want to continue employment so that you keep topping up that pension naturally. Again, that's something that you'd see potentially escalate to an employment tribunal. In a situation like this, where there's going to be so many changes over the coming weeks, over the coming months, over the coming years with the emergence of the Employment Rights Bill, again, have your documents reviewed by a professional. Again, pop me an email following this. We review documents for free. We don't charge anything. We'll give you some advice on that, and try and get ahead of the curve. The Employment Rights Bill is not going to wait for anyone. The Fair